Good afternoon and welcome to today's webinar titled Thinking of Nursing Home Litigation? You Should. My name is Mike Santilli and I am pleased to host today's program featuring Melissa Miller of Howie Sachs & Henry LLP and Eric Joffe of Neinstein Personal Injury Lawyers. If you experience issues or need assistance, you can contact the OTLA office by calling 905-639-6852. This program is eligible for up to 1.25 substantive hours. We encourage you to ask questions throughout the webinar. Submit a question anytime using the questions panel right near the bottom of the GoToWebinar interface. You can also email me your question to msantilli@otla.com. We will try to answer as many as possible at the end of the program. Our presenters have made a PDF copy of their slides available to you for today's presentation. You can find the PDF in the handout section of your GoToWebinar interface. I would like to take a moment to introduce our speakers for today's webinar. Melissa Miller is a partner at Howie Sachs & Henry LLP. Melissa is an advocate for the most vulnerable members of our population, the elderly. Being certified in elder law, she concentrates on nursing home negligence, long-term care cases, and elder abuse. Her practice is also committed to all areas of personal injury litigation, including product liability, hospital negligence, car accidents, slip and falls, and long-term disability claims. Melissa is a trusted advisor who supports and guides clients through the legal issues that need to be resolved as they fight to recover. Melissa is an experienced trial advocate and is prepared to take her cases all the way. Melissa is a member of many professional associations and frequently authors articles for these associations and other organizations, including updates on the law, catastrophic impairment, and important issues that affect the rights of injured victims. Melissa was elected to the Board of Directors of the Ontario Trial Lawyers Association in 2017. Eric Joffe joined Neinstein Personal Injury Lawyers LLP as a summer student in 2011, continued with his articles, and is currently an associate lawyer at Neinstein. His practice focuses on long-term care, home negligence, and nursing home negligence, in addition to other areas of insurance litigation. He recently obtained a certificate in elder law from Osgoode Hall Law Society. Eric completed his Bachelor of Arts at McGill University, where he obtained a double major in political science and sociology and graduated with distinction. He then went on to graduate with a JD from Queen's University Law School. He is an executive board member of the Brain Injury Society of Toronto and volunteers with Lawyers Feed the Hungry. Ms. Miller and Mr. Joffe, thank you for being with us today, and I welcome you to the program.
Thanks so much, Mike.
Thanks, Mike.
And thanks, everyone, for attending. Excited to talk about this. Eric and I actually both realized we shared a passion for elder law and these types of cases when we took our elder law certificate course from Osgoode together. So happy to be presenting with you, Eric.
And a big congratulations to you, Melissa, on being made partner at Howie Sachs. Wonderful news.
Thank you. Thank you so much. All right, so the reason why we've decided to do this webinar is nursing home negligence is an area of law that people are talking more and more about. There's cases appearing more and more in the media, and that's because the elderly, as we know, are a uniquely vulnerable group. We're talking about a group of people with diminished health, mental capacity, financial limitations, and this group of vulnerable people have been subject to various types of abuse and neglect that we've seen recently. So, and also this mirrors the recent edition of the Litigator magazine. So if anything that we're talking about can likely be fleshed out in the edition of the Litigator, and we wanted to time things accordingly.
Yeah, and I mean, it goes without saying that many elderly people and this portion of the population don't have the ability to advocate for themselves due to age-related issues. So it makes it all the more important for lawyers to be knowledgeable in this area.
And I don't know about you, Eric, but I find that how these cases come across my desk is, there's people, families, residents who don't understand their rights. They don't know how to advocate for themselves, and that's how mistakes happen. That's how abuse happens, and that's unfortunately why these types of cases need to be litigated.
Absolutely. So I'll just go over some brief statistics for everyone. In 2012, there are 634 long-term care homes in Ontario that provided about 78,000 beds with a 99% occupancy rate at any given time. At that time, there were 19,700 residents awaiting placement, which creates a demand well above available resources. So residents often search for any open space as opposed to the right fit, so to speak, in a long-term care facility. Something to note here is that once a resident is accepted into a long care home or long-term care residence, the facility can't just have a resident removed. The facility becomes their home, and basically eviction is not an option except under extreme circumstances such as hospitalization. So some more up-to-date stats for you. The average time to placement in long-term care as of February 2019 is 161 days, and the wait list for long-stay beds as of February 2019 is over 34,000.
These stats are important because, the one question I get asked is, well, is this really an area of litigation that's viable? And 100%. I mean, right now, 15% of Canadians are over the age of 65, and by 2036, the seniors are going to represent about a quarter of our population. And 85% of the residents that Eric was just speaking about require extensive help with activities of daily living. Most have some sort of cognitive impairment, mood disorder, and need monitoring for, some sort of acute medical condition. So the population is increasing. The stats that Eric was referring to highlight the fact that, we're already bursting at the seams. And unfortunately, I think this means that is going to mean more neglect and abuse. And it's incumbent upon personal injury lawyers like us to be willing to take these cases on and push the boundaries and test the limits and advocate on behalf of our most vulnerable, as we do so well with our other clients.
Absolutely, and it also goes to sort of being creative with respect to how you're framing your claims, which we'll get into later.
Yeah. So the first thing to note, we talk about nursing homes as, a category, but really in Ontario, nursing homes really mean two things, and people get them confused and use these terms interchangeably. What you really have is retirement homes and long-term care facilities, and they're hugely different from each other. Retirement homes are governed by the Retirement Homes Act and the Residential Tenancies Act. For all intents and purposes, a retirement home enters into a lease with a resident and provides, meals or other types of care. And there are different, you might hear a client say, oh, my parent was level 1, level 2, level 3. Those are the different care models that can exist in a retirement home and entered into by contract. So it's important that you understand the Residential Tenancies Act, because people can be evicted from retirement homes even though they can't from a long-term care facility. And there is a body that oversees retirement homes, and that's the Retirement Home Regulatory Authority, which is a body that will do investigations when complaints are made and has their investigations made public. And we'll talk about that in relation to the Ministry of Health and Long-Term Care later. Retirement homes are private. They are a private contract between the public or the residents and the home. They are a for-profit model 100% of the time, unless there's, an exception because it's a government-funded or subsidized one. But for the most part, they're all private rates. And the monthly rates will vary depending on the care needs. It could be $3,000 a month, it could be $20,000 a month. It really depends. Conversely, long-term care facilities are governed by the Long-Term Care Homes Act. It is the Bible legislation and the regulations made there too. They're licensed by and regulated through the Ministry of Health and Long-Term Care, so that's the body that does investigations when complaints are made. You access the long-term care home through the Local Health and Integration Network. It used to be called CCAC, so you might be familiar with them from that perspective. So the LHIN is the controlling body that liaises between a resident and the home to get access. Long-term care facilities have standardized rates and are partially subsidized by the Ministry of Health, and the average resident pays $1,500 to $2,500 a month over and above what the government is contributing.
So I'll just read Section 1 of the Long-Term Care Homes Act, which sets out the fundamental principle to be applied in any interpretation of the Act. So it states that a long-term care home is the primary home of its residents and is to be operated so that it is a place where they may live with dignity and in security, safety, and comfort, and have their physical, psychological, social, spiritual, and cultural needs adequately met.
And similarly, the fundamental principle in the Retirement Homes Act reads that it is to be applied in the interpretation of the Act and any regulation, order, or other document, that a retirement home is to be operated so that it is a place where residents live with dignity, respect, privacy, and autonomy in security, safety, and comfort, and can make informed choices about their care. So some similarities, and you'll see throughout that there is more of a focus on autonomy in retirement homes than there is in long-term care homes, but they're both, holding dignity, respect, security, and safety as similar and top priorities, which leads us to a discussion of the Resident Bill of Rights. So in the Long-Term Care Homes Act, there's a Resident Bill of Rights that's listed under Section 3. What's important to note about a Bill of Rights under the Long-Term Care Homes Act is that that Bill of Rights actually forms a contract. So I can't remember what section it is, but the Long-Term Care Homes Act, there's a section that says it is meant to be read as if the home and the resident entered into a contract with each other, which means a violation of one of these Bill of Rights is a contractual violation between the resident and the home. And that's really important because we'll get to breaches of contract later. But you'll see that the Resident Bill of Rights under Section 3, I've listed the categories here: dignity and respect, prevention of abuse and neglect. There's bills of rights around care and services, consent and choices, minimizing restraints, and then about communication. So there's a ton of different Bill of Rights listed. I'm not going to go through all of them, but one of the ones that I find particularly interesting is that the resident has a right to have treatment that encourages rehabilitation and independence. The reason why I find that one particularly interesting is often I hear complaints of, people's mobility decreases when they get in the home. If they were in a wheelchair, they're now bedbound. If they were using a walker, they're now in a wheelchair. That's something that I look at to see whether the home is actually complying with that particular Bill of Rights. Obviously, they have the right to be protected from abuse and the right to be protected from neglect, which are actually separate rights. Living in a safe and clean environment, being able to form friendships and relationships, having political autonomy if they have capacity to vote. So honestly, the Bill of Rights are meant to encompass all aspects of a resident's life while they're present at the home. And then similarly, you'll see on this slide, the Residents' Bill of Rights under the Retirement Homes Act in Section 51, there are similar provisions, but as I said, the Retirement Homes Act is focused more towards autonomy, independence, so the rights are about consent and choices and having knowledge of the care services provided, making sure that they understand the rights and responsibilities of each of the home and the resident under the Residential Tenancies Act. So it's about informing the resident and making sure that they're making informed choices and that they can consent and be independent in their own care.
We'll also talk a little bit about some different types of cases that we've seen. So Melissa's going to give you a list, and and then I'll talk a little bit about some pre-litigation considerations.
Yeah, I mean, in terms of, we all understand that, you know, negligence cases are probably the primary avenue in terms of causes of action. But under negligence, in my experience, there's, you know, the single instant cases, which are, you know, kind of like your, I don't want to say the easier ones, but they're at least easier from a documentary investigation standpoint. So falls, abuse, you know, those are things where there's probably a critical incident report or something documented in the notes, as opposed to things that are more systemic, like pressure injuries, which are bed sores, pressure ulcers. They're not called those things anymore. Pressure injuries is the new lingo, and that's because of the obligation of staff to identify a pressure injury before it gets to an ulcerous stage. Medication errors, and then unfortunately, malnutrition and dehydration are really difficult systemic cases. They're difficult to hear about, they're difficult to read about, and it's shocking when you think about how someone in Canada in 2020 can die of malnutrition and dehydration. And so those last three bullet points are really what I would say are more systemic areas of negligence. And then we'll talk more, like there's breach of contract and breach of fiduciary duty, and punitive and aggravated damages that are available as well.
And you're also considering assaults by other residents. This really does tie into a resident's right to live in a safe environment. So you might often not really think of the long-term care home as being culpable in a situation where you have one resident assaulting another, but you have to look at it from a broader perspective in that sense. I'm going to talk a little bit now about pre-litigation considerations. Obviously, the Personal Health and Information Protection Act is something you need to consider with respect to disclosure of a resident's information. You're going to need consent there. You might need a court order, and you need to keep in mind capacity to consent with respect to a substitute decision maker perhaps being required. So another thing I want to talk about is the ministry itself and their role in terms of investigating and inspecting homes. The ministry is there to ensure compliance with the acts and regulations, and it's important to keep in mind in any sort of pre-litigation stage, you want to ask a potential client or a client whether an investigation has been done by the ministry, and that can be spurred. An investigation can be spurred by a complaint or an inquiry by a family member or an elderly individual in a home. They'll call the long-term home care action line. And that's a toll-free number, and I can provide that to everybody later, but it's a really good first step when you have a potential client or a new client calling. You got to encourage them to make that complaint to the ministry through this action line, because it's going to spur an investigation. And I've seen some pretty valuable pieces of information come from those investigations. They're also posted publicly. There's an online database of all long-term care homes in Canada that's located on the Ministry of Long-Term Care website. You can see inspections and investigations that resulted from, or that result in different forms of disciplinary action against a long-term care facility. So I like to think of it similar as to like a CPSO complaint database. And good to keep in mind that failure to adhere to these standards can often result in the loss of a license of a care facility. So the other question that you're going to want to bring up, sorry, go ahead, Melissa.
No, I just wanted to anecdotally provide that sometimes when people are calling me, they're like, oh, I've made several complaints to the ministry already. They don't do anything. Encourage people who are calling you to make the complaint anyways. The investigation is really only as good as the inspector doing the investigation, so some are better than others. The other thing to note is it depends on what people are complaining of. If people are if the potential client is calling you because they think that their parent has been receiving mismedication, but they're calling and complaining about not having been informed as the substitute decision maker, then that's what the ministry is going to investigate. So you want to make sure that a potential client is complaining about all of the things that they're, concerned about. And then when the ministry is doing the investigation, it's not going to read like a liability report that might be super helpful to us. They're going to investigate whether there have been infractions in accordance with the regulations and the Long-Term Care Homes Act. So sometimes, a scathing report simply means they didn't call the family in time after an event happened. And then that's not like super helpful, but other times, they basically make all of the findings you need in your case. So it's...
Yeah, and you can find in those investigations patterns of non-compliance in various homes. I find that to be actually very helpful, especially in any sort of discussion with the home or whoever their representative is, because you might find almost a catch-all. You can find your client, and mind you, they're all sort of anonymously reported, so you have like numbers of PSWs, numbers of residents rather than names, but you might find that there are patterns of non-compliance, as I said. So it's not just your client that is being spoken about in the investigation. It could be several members of a long-term care facility and several infractions.
And the RHRA, the Retirement Homes Regulatory Authority, does the same type of reports, and you can find those too. And once again, they're looking at breaches of infractions and care plans, which we'll get into.
Yeah, another thing to mention is our coroner's reports. A lot of times clients will call, and it's important for a lawyer to try and to determine whether a cause of death is connected to negligence in a long-term care facility. So that can be really tough, and enlisting the help of the Office of the Chief Coroner to even do a retroactive report can be very helpful in terms of collecting evidence.
Yeah, for sure.
Another thing I was going to touch on was just litigation guardians. Obviously, the issue of capacity can come up often with elderly clients. You've got to have that top of mind. If you as a lawyer suspect that a client or a potential client might not have capacity to understand legal instruction or opinion, a capacity assessment might be required. I'll put a little asterisk here. Capacity comes in many different forms, so be mindful of that. If a lack of capacity is known, litigation should obviously be initiated through a litigation guardian or the PGT. Otherwise, it's usually a family member. Again, mental capacity of adults needs to be assessed on an individual basis. Diagnoses which affect capacity, like acquired brain injuries or mental illness, are not determinative as to whether an injured adult can retain and instruct counsel. So an adult is presumed to be capable of making his or her own decisions, and including being able to hire and instruct a lawyer. You want to look to the Rules of Civil Procedure. You want to look to the Substitute Decisions Act for guidance in terms of litigation guardians being involved. And something to note is if a mentally incapable adult has a previously executed power of attorney, when he or she had mental capacity, the POA will act as the litigation guardian. So if the incapable adult does not have a family member or a friend available and willing to act as a lit guard, then the Office of the PGT is going to be stepping in there. So again, litigation guardian, separate, totally separate from a power of attorney for care, which is separate from a power of attorney for property. So it's important to parse those out and understand the nuances.
And also that, practically speaking, full disclosure, I would say 75 to 80% of my cases, the resident died as a result of the negligence. So, we're not really dealing with litigation guardians that much, I would say. But in the other, 15 to 20% you are. And, then it's, because people confuse, I'll get people call me up and they say, oh, well, I'm power of attorney when the person's dead, and, that has, the power of attorney document loses all force and effect. Then you need to find out who the executor is of the will to obtain any relevant documentation. And if there isn't a will, then, there are ways around it. You don't necessarily have to probate the estate, but you do have to prove next of kinship. So sometimes, having a marriage certificate or a birth certificate showing that they're the biological child or the spouse, then you can submit that with your authorization signed by that person to get the records. But the other thing that I was going to add on the capacity issue and consent issue, as Eric said, it's all individual basis, and there are very different kinds. And one of the things that I notice as I'm reviewing a file is the staff at homes have little to no understanding about capacity and consent issues. And most people say, as a blanket statement, this person lacks capacity. That's not an accurate way to look at any kind of capacity, because with respect to personal care, because the property component is not, super salient at this point, but if you're evaluating someone lacks capacity for personal care, well, what care are you talking about? Do you lack the capacity to make decisions about your nutrition and what meals you want to eat? Or do you lack capacity to make a decision about a potential surgery? The question needs to be asked at every stage, and with respect to each component of someone's personal care. And what often happens is a resident in a home will not even be consulted about some of the very basic things in their care plan when they should be. And that's something to keep an eye out for, and involve someone who specializes in capacity and consent as an expert if necessary.
Another thing I was going to mention in terms of pre-litigation considerations is, you probably hear this a lot, but know your client, who is your client? You need to understand that often one very concerned, son or daughter is going to come to you, and you need to ask the question of, if you're going to be retained, there could be multiple Family Law Act claims. So you want to make sure that you understand, who's the estate trustee, who's actually making the decisions. Is the entire family on board? Is somebody going to come out of the woodwork later on down the road in litigation and, really could really put a wedge in things, so to speak, if you haven't involved them in the process. So at the outset, you really do want to make sure you understand and the family understands who the decision makers are, who the actual clients are, what the FLA claims, consist of. So that's absolutely something to keep in mind as well.
Yeah, and I'll get into this more when we're talking about damages, but what I typically do is I set up a conference call with all interested family members or a meeting, and I make sure that they understand that each one of them are clients. I get each one of them to sign the retainer so that they all know, and I talk to them about potential conflict, and what would happen in that situation, just so that they understand that while there might be a spokesperson and a primary point of contact, they each have rights as a client.
Yeah, and that's a really good point, Melissa. And you're going to want to have a conversation, a very candid conversation. What do they want to get out of this? A lot of concerned daughters and sons that come to my office are really looking not just for sort of justice for their loved one, but also to make sure that this doesn't happen again. So policy changes, they want to see that kind of stuff in any sort of settlement or any sort of resolution. And it's important to have that discussion from the outset, because a lot of times people are just looking for these facilities to take responsibility for what they've done, rather than some sort of monetary compensation.
That actually, we can probably add to this list that, if you think about media is a pre-litigation consideration. I'll tell you, I can jump up on the soapbox and talk about elder care all day, and I'm looking for that in my clients, quite frankly, because I don't know about Eric, I think you feel the same way as I do. My preference would be to litigate myself out of these types of cases eventually, improve elder law or elder standards in Ontario so that we don't have these things happening anymore is obviously the ultimate, pipe dream, right? And so when I'm communicating with families and when I'm considering taking them on, A, I've never had anyone say that they're in it for the money, but B, I'm looking for people who are willing to, use other branches aside from just a lawsuit to achieve that type of change in justice. I tell every single one of my clients to write to their MPPs, write to the MPP in the riding where their parent was resident, and see if they're willing to engage with the media. And then if they are willing to engage with the media, it's about their experience and what happened without talking about liability, and quite frankly, without really involving me. Other than a mere mention that I might be counsel, I don't really like to be a part of the story. I like to keep it about my clients, because this is what is going to form that sort of grassroots movement.
That's a really good point, Melissa. And I guess on that note, you might consider social media as another outlet for a lot of attention to be drawn to these issues. And I think that'll be more on the forefront as you know, our population demographics change.
Oh yeah. So the last thing on, you know, in terms of pre-litigation considerations, nanny cams, I put it here because I get a lot of calls from families asking me about nanny cams. And if people are calling me, they're suspecting abuse and neglect in the home, their parent is still there, they haven't been able to put them on a new wait list with the LHIN, or they're on a wait list and waiting, if they don't already have a nanny cam, I say get one in there. They're perfectly legal. Now, I will say this. Under the Criminal Code, Section 183.1 prohibits audio recording of a conversation if there isn't at least one person's consent. You know, this raises an interesting issue in these kinds of cases where you're questioning the capacity of the resident and their ability to give that consent. The million-dollar question is the substitute decision maker who put the nanny cam in the room enough to provide consent? I don't know the answer to that. And when people are asking me about this, I say, look, it's a risk you're taking. If you do want to have the audio on there, I mean, I'll tell you, I have clients who've given me the audio, super helpful. I mean, really helpful. I haven't gotten to the point where I've disclosed audio yet and see how that pans out, because this was a pretty recent production. But it's a risk, and I tell people about the criminal code section, and I say it's totally up to you. It's perfectly legal to have a visual-only nanny cam. I'd rather not have one of my clients be the test case for a criminal charge for recording audio without consent. But I mean, it's people who are willing to take that risk. I tell you, I get some pretty good gold on that. All right, so timing of cases, obviously something that we want to consider with the elderly, especially if they're alive and in the home. You know, we want to be moving these cases forward as quickly as possible. And even, you know, like I said, even though most of the residents have passed away as a result of the negligence, the families still want pretty speedy closure. And from a business perspective, you know, if you're taking on these cases, you want to have a short window that you're injecting time, money, and effort into these cases. Have a quick turnaround. We're not talking about, you know, multi-million-dollar or, you know, several hundreds of thousands of dollars of cases. You want to move them quickly. So how do you do that? You put a lot of time and energy into the investigation of these claims. By the time that retainer is signed, you should have a really clear idea about the theory of your case, where it's going, and be able to execute really quickly on either an early resolution or expeditious litigation. So there's nothing obviously in the rules that we can rely on to help move these cases faster just because elderly people are involved. But, you know, like I said, if you want to move the file really quickly, like for me, if I think that I'm going to be moving towards litigation, I get my expert report from my nursing expert, you know, right off the bat. I serve it with a proposal and a demand. And if they're not willing to pay that, or at least sit down and negotiate, start the claim, get it moving, and, you know, move through it. Don't grant waivers of defense, or, you know, do so expeditiously. But you can't. My experience is that the faster you move these cases forward, the better the result is.
And you don't need to wait for a lot of these cases for the right time to get an expert report. Like, you may as well do it at the outset, because as long as you have all of the production, For example, you're litigating on behalf of an estate, like there's no new records that are going to come out. So just make sure you have the full production before you get your expert, but no sense in waiting just before a mediation, for example.
Yeah, and I mean, keeping in mind too that there might be a court approval process if the resident is still there and lacks capacity, so you got to, add that time onto it as well, right?
Yeah, the other thing Melissa and I were speaking about prior to starting this was Rule 76, like the simplified procedure. There's a $200,000 cap. I'm just throwing it out there. I haven't actually pursued this avenue yet because I'm quite weary of the ability to file a jury notice in that scenario or under that vein. But
well, yeah, because you can't. There are no juries with, and the thing is, like, that's when you have to sort of sit back and assess. Okay, do I want a jury? I mean, 9 times out of 10 on a nursing home case, you want a jury.
Absolutely.
I can think of exceptions where maybe a jury isn't going to matter, but honestly, and again, we'll talk about this when we talk more about damages and how we plead these cases, but there's always going to be an element of some sort of discretionary damage that, in my opinion, we want to have a jury on. So even though a simplified procedure might be, an expeditious way to go, I might only be inclined to do that if I know that my client is alive, is injured, has a limited life expectancy, and it helps my case to have them alive. Let's say there's a future care cost component to it, and I don't, want to have a crystallized future care cost claim because they passed away. So that might be the only reason why I'd want to expedite through simplified rules, but otherwise, especially if they've passed away, I think I want a jury on almost every case.
Absolutely. You just want to keep in mind that it's probably not in the defendant's best interest to move these cases along expeditiously. So it really does fall to the plaintiff to make sure they're spurring the action along.
Yeah. So liability in nursing home negligence cases, in the way I sort of broke this down, you've got simple cases, which I characterize as clear breaches of a care plan. So let me address the care plan for a minute. I mentioned earlier under the Bill of Rights when I was talking about it that there are care plans. Under each of the legislation for the Long-Term Care Homes Act and the Retirement Homes Act is the requirement for a multidisciplinary assessment to be done of the resident upon entry. The Long-Term Care Homes Act has, further stipulations about how often the care plans need to be updated. But what you need to understand is that care plan is the Bible, the be-all and end-all of a resident's care. Everything from, especially in long-term care, how often they brush their teeth, to what their preference is in terms of room temperature, to how often they need to be turned in bed, their meals, is it a liquid diet, a solid diet, a low-salt diet, do they need assistance with transfers, you name it, every single aspect of your care that you probably don't even think about is supposed to be assessed in that care plan. So the very first thing that I look at is the care plan, and I compare it to the progress notes, and that's usually the thing that the Ministry of the Retirement Home Regulatory Authority will look at when they're doing an investigation. So right off the bat, you find a breach, boom, there's liability. So I find, and in most cases, we're talking about breaches of care plans. Some cases, which are the more complex cases, are where you're looking at the appropriateness of that care plan to begin with, or more systemic types of negligence, neglect, and abuse, like I was talking about earlier, malnutrition, dehydration. Those are things that occur over a longer period of time and are not as simple to prove as like a fall during a one-person transfer when it was supposed to be a two-person transfer.
So I'll talk a little bit about standard of care. So a useful analogy, mind you, there's not a lot of case laws, Melissa mentioned before, on nursing home and long-term care facilities. There just really isn't, and that's Canada-wide, especially so in Ontario. Obviously, that's going to change as demographics change, but for the time being, a useful analogy in terms of a standard of care that's often been used is that of a hospital to its patients. Very important to keep in mind, we've been mentioning all this legislation, all this regulation, all these regulations, all of these things that go into a long-term care, the initial assessments, all of that. So the standard of care is really informed by legislation. So we've got the Long-Term Care Act, as we've mentioned. We've got the related regulations, which you should be well versed in. And there's a ton of Ministry of Health manuals which lay out standards, guidelines, procedures, and that's invaluable information there, especially when you're preparing for a discovery. So you got to know that stuff cold, and inform yourself. What are the standards set out by the long-term care facility itself? What does the contract with the residents say? Again, we want to consider the fundamental principle found in Section 1 of the Long-Term Care Act there as well. Another standard of care, obviously, that you're going to be framing it under is the Occupiers Liability Act, which imposes a positive obligation on a long-term care home to take such care as in the circumstances of a case that's reasonable to see that residents are reasonably safe. So, you know, there have been no reported decisions dealing with the issue of whether all the circumstances of the case creates a higher standard of care for long-term care homes, but given the vulnerability of this portion of the population, the courts definitely could expand that definition.
And, you know, so if you're thinking about an occupiers liability case, it's like, I have a case where a guy tripped over a telephone wire in his room. And so that case is, you know, normally you think, okay, well, you're not going to sue someone because you tripped over your own phone cord, right? But again, to Eric's point, you know, he's particularly vulnerable. He's noted to be a fall risk, and they didn't properly secure the telephone cable. So that's something that I would frame that under an occupier's liability, in addition to, you know, being under the regulations and a breach of standard of care, care plan.
Absolutely. Another good area of the Long-Term Care Homes Act is Section 17, which creates a duty on long-term care facilities to ensure that staffing is sufficient to meet various care standards created by the regulation.
Yeah, I mean, I don't know about you, but I find that the common denominator in almost every single one of these cases is lack of staff, you know?
It's a recurring issue,
yeah.
Absolutely.
And then, you know, noted here under precautions by home, the home in maintaining precautions themselves might have evidence for you, like surveillance in the public hallways. If I have a few cases where my resident was either pushed in a hallway or fell or something like that, and it was caught on tape. So if you suspect that something happened, not in their private room, that's not allowed, they're not allowed to be surveilled in there, but in the hallway, then when you're doing your notice letter, make sure that you're asking them to preserve any surveillance, because if they don't, and you know that they had it, obviously, you know, you can argue spoliation. And then, as Eric said, like their own policies and procedures, make sure that you're getting production of that before discoveries in their affidavit of documents, and you're not just asking for it as an undertaking. All right, so one of the things that is obviously really important to consider is who you're suing and how you get access to the insurance, right? And one thing, thankfully, that we don't have to really consider is, you know, whether vicarious liability is going to be an issue. It's not. The home is vicariously liable for all of the staff that are there, and it doesn't matter if you're talking about an intentional tort like abuse or neglect, because as we know from the case law, the most salient case is the Basley and Curry case. You know, these staff are provided with the opportunity, right? They're provided with the opportunity to do that. And the question in each case is whether there's a connection between the employment enterprise and the wrong that justifies the imposition of vicarious liability. So again, you know, the PSWs, the nurses, even if they're sexually abusing a resident, the home is still going to be vicariously liable. So don't shy away from some of those that you might think would otherwise be an intentional tort case. And I mean, for that matter, there are various kinds of elder abuse. There's financial. That happens less, I would say, although I do have a case where a home permitted this financial advisor to go in and start signing people up for these like lifetime policies or lifetime annuities in their investments. And there's a clause in the annuity policy that allowed the insurer to keep a large portion of that if they died within a certain period of time. So that's something to consider. That's certainly financial abuse. Emotional abuse, we'll talk a little bit about this more later with dementia patients, but this I find to be rampant. It's very emotional for the residents to be in the homes, and certainly my EQ has improved since doing these cases. But I mean, you know, the impatience with which many of the staff approach the residents can feel emotionally abusive to the residents, and that's something that can often be caught on a nanny cam, and is difficult to prove otherwise. But it's probably the most common type of abuse I see.
On the vicarious liability note, just something to say about physicians that work at these facilities. So, you know, unlike their position at a hospital as an independent contractor, doctors at long-term care facilities are on contract, or they receive a stipend. So the CMPA is still going to represent doctors who work at long-term care facilities, but you need to frame and you need to ask it sort of a different question to address that relationship that doctors have at a long-term care facility rather than at a hospital. So long-term care facilities can be held vicariously liable for the actions of physicians and also for the selection of those physicians. So you need to think, like, does this physician have any particular knowledge or specialization such that they will be fit to deal with this portion of the population, right? Do they have any experience or training in geriatrics at all? These are questions you really want to ask. It's important to note that nursing and long-term care facilities have much more control over physicians than hospitals. There is that signed contract of employment. Like, always go back to that. You should request a copy of that employment contract. It'll set out expectations of a physician with respect to the level of care that they're expected to provide at any facility.
And for that matter, a lot of the nurses and PSWs are privately contracted as well, but the home is still vicariously liable for them because they're, you know, for the same reason. And that's something to monitor as well, because what I find is that the contracted PSWs and frontline workers at the home are usually on the night shift. They know the residents less than the full-time staff, and that's where most of the mistakes happen, on average, in my experience. So that's certainly something to keep in mind and ask, you know, if you want to get a sense of whether they've got a revolving door of contract staffers coming in or whether there's any consistency, because those are how those systemic types of negligence, or those more complex negligences like dehydration and starvation cases, persist. So an interesting area is elder on elder abuse. And Eric and I were talking about this before we started the presentation today. You know, there's a fine line between neglecting to keep one resident safe from another resident that has violent or abusive tendencies, and also not violating their right to form independent relationships. And depending on the level of care, your client or the resident might be in a particular ward where, you know, wandering is permitted and they're allowed to go into each other's rooms, and that's perfectly fine. They're allowed to have friends and sometimes even girlfriends or boyfriends or what have you. And it's a really important part of their well-being to be able to form these relationships themselves, but while at the same time monitoring that someone with abusive tendencies isn't allowed to be alone And Eric, you're telling me about one case.
Yeah, I had a case recently that was actually settled pre-litigation. An individual was on the same floor as my client, and had a long track record of being very aggressive. And issues were raised by PSWs who didn't actually work for the home, and they were hired by the family as an additional layer of care. And I was able to get will stays from them saying that they had raised this issue, these concerns that this individual was going to hurt my client or somebody else on the floor. And that issue had been raised multiple times and nothing had been done. And sure enough, a very catastrophic injury resulted from my client, who was a known wandering risk, entering the room of this individual and being assaulted. So very, very important to keep in mind, again, that there is a tenet to keep everybody safe in these homes. They have a duty, an active duty, to make sure that they are aware of the tendencies of different residents, and to inform not just the higher levels of staff, but everybody working there needs to know, what sort of interactions might be dangerous.
And the substitute decision makers need to be informed as well, and that needs to form part of the plan of care if necessary. So, I had a very similar case, but in my case, I just signed it up. I don't have will stays yet, but there were 3 prior assaults on the same morning, and this person wasn't restrained. And, restraints are permitted under the regulations in certain circumstances, especially when the safety to themselves or others is at risk, and they didn't do anything. And same thing, my guy was pushed in the hallway. It was caught on surveillance. This was because it was one of the public hallways. And he also died from a subdural hematoma. So it's, it's sad, but those are the kinds of cases that you can prove elder on elder abuse. I've had people call me about sexual assault. Those ones are harder. It's really difficult, especially if they have any dementia or Alzheimer's. If they're not able to recount the story and there's no one who saw it or no one knows, it's just almost impossible to prove. All right, damages. This is probably one of the most important parts that you need to know about, because this is where the money comes in. This is how we get paid, right? I mean, look, let's call a spade a spade. One of the reasons why people have been reluctant to take on nursing home cases is they think the damages are peanuts. And, when we all work on a contingency fee basis, we're not going to make any money. Well, I can tell you that actually there is some serious money potentially in these cases, and we're going to tell you why. So first of all, people always say, well, because when you're evaluating pain and suffering, they were old anyways, they were going to die soon anyways, and really there's something called the golden years argument, which is a shield to that type of a defense. And in Ontario, we see that in the Schmore Estate and Weber decision. There's also some BC cases. I actually go through this in my article in the Litigator, so there's more information in there. But really, the idea is that you're looking at quality over quantity. So you take someone who already has very, very limited enjoyment of life, and you remove one aspect of that, can have devastating consequences. And so our courts are latching on to the idea that, you shouldn't be allowed to reduce a pain and suffering award just because someone is old. In fact, it should have the same financial consequences as someone who is young and healthy, potentially.
Another point we touched on before was family law claimants. Again, there is power in numbers here. You need to be wary of, sort of family drama, we'll call it, or estate issues. Obviously, that needs to be top of mind, but there really is power of numbers here. Like these FLA claims, if you take them in a compartmentalized way, it's not a lot of money, I suppose, from a plaintiff lawyer's perspective. But you add them up, you have 4, 5, 6 FLA claimants. Like it really can add up. You can get into the hundreds of thousands quite easily just on FLA claims alone. not to mention claims for pain and suffering from the estate for the time that the person actually was alive for, something that's overlooked a lot. Melissa and I have been talking about it a lot, but look to the two cases, Singleton and Leisure World, which is a very, obviously a very cited case, and Madonia and Stevens.
And actually, you know, just because you were talking about damages on behalf of the estate, and I was talking about pain and suffering, one of the areas that I'm increasingly becoming interested in from a factual or scientific standpoint is the impact of emotional abuse on patients with dementia. And I mentioned this earlier. So you take someone who is basically being force-fed their food, they start, you know, turning down meals, they're scared of the PSWs who are coming in, and, you know, they're becoming malnourished and dehydrated. Or you take a person with dementia who was the victim of abuse and now there's serious abuse but doesn't remember the event. Each of those cases have nuances with respect to the dementia component that I think is worth investigating with the geriatrician. And the reason is dementia patients experience trauma differently than you and I. And it depends on which part of their brain is being affected by the dementia. But what we know is, for the most part, if they're not able to recount facts, they certainly remember being afraid. And it's in fact more terrifying for them because they know something bad happened, but they don't know what. And so their alert is on 100% of the time, and they trust no one. So I'll give you an example. I have a client where her father was sexually harassed. The PSW was like patting him on the bum and like cupped his butt. I think she was trying to be like playful, but it really upset this man, and he was devastated by it, but then didn't remember what happened. It was caught on video, and the daughter was standing right there. Well, what's the impact of that? Now, he doesn't trust anyone at the home to shower him or feed him. And so the daughter now has to come and shower him and feed him because she's the only one that he trusts, because she's the only one that he can recognize. That's a devastating impact with respect to his claim, but also with respect to the daughter's FLA claim. And it's a way to bolster her FLA claim as opposed to it just being a loss of companionship. It's also the value of services that she's providing that needs to be quantified.
That's a good point. It goes to future care costs as well. Having to remove somebody from a home is extremely expensive, and a lot of people simply can't afford it. So it's important to keep in mind what are the increased care costs. Melissa was mentioning before, you know, before we got on here, you don't really all the time need an expert report for this stuff, right? Like it can be simple math. You have an increased monthly fee, increased services, etc. Like, you know, that's pretty quantifiable, and it's something to keep in mind when you're evaluating, you know, the upside of these cases.
Yeah, and it's simple math, and because these people are usually going back into another facility, they calculate all of that for you. One thing, I don't know if this is a viable argument or not, but estate expenses. I've advanced it in a couple of my files where I've had to, so as a result of the death, I've had to deal with, you know, some estate issues, you know, to probate the estate in order to get access to records or something like that. You know, I'd argue that you could throw those in if you're getting the records for the purposes of litigation. And also, you know, funeral expenses, things like that. I know that look, I make the pitch, I include it. They argue that, you know, they probably would have needed those funeral expenses pretty soon anyways, but I still make the argument, and it creates exposure.
Another thing Melissa was mentioning is breach of contract. Again, people are paying for a service, and there are certain expectations that go along with it, and that, you know, if you have a fundamental breach of a patient over a number of years, and expectations are met or you know, absolutely not met. I don't know how else to put it, but a real fundamental breach of contract there. Those numbers can add up as well. It's definitely a consideration, and it should find its way into your claims as a claim for punitive damages. If warranted, should find its way into your claim. Again, no cap on punitive, so it's an area that absolutely needs to be explored in this area of law.
Yeah, I always include fundamental breach in every one of my cases. And sometimes, the fundamental breach or the breach of contract is only a breach on one day, and sometimes it's a breach over a period of time. But one other thing that I didn't include on the slide that occurred to me I pled recently is the loss of a beneficial interest from the estate of the resident. So I have a case where the woman was she was abused in the nursing home, and the daughter had such a reaction, and her mom was so untrusting moving forward that her daughter actually pulled her mom out of the home and brought her home to do home care. And mom has money in her estate that daughter is now using at the tune of $10,000 a month to care for her, which I say is eating into her beneficial interest in her mom's eventual estate. So it's something that, again, can be quantified. Most people who are in homes, are living off of a RIF, and that's something that can easily be assessed by any financial expert or accountant.
Yeah, the last thing we'll touch on is just OHIP subrogated claims. It's not. Melissa and I were sort of going back and forth on this before. Like, do you always need to call OHIP in any sort of case like this? Like, no, not necessarily. If it's purely framed under an FLA claim, you understand when you need to notify OHIP, and that's when OHIP is paying for the care, or the increased cost of care for an individual who's been injured. So in most cases that'll happen. You'll have a very short window where shortly before somebody passes away, you have that increased care. But you do need to keep OHIP top of mind, because there often is a subrogated claim. And that subrogated claim, when someone is injured and their care needs go up drastically, or they're hospitalized for a long period of time prior to their death, that can get up really, really high. So it's certainly something to keep in mind, and it's something where you might negotiate a discount at the end of the case.
Yeah, and I mean, the nice thing about the OHIP subro claims for these cases is, if there's a very clear breach of the standard of care and liability is not too much of an issue, OHIP's not taking a cut in the way that we have to on like a slip and fall case or an occupier's liability case where liability might be an issue. OHIP can get 100 cents on the dollar, and I've actually negotiated OHIP settlements separate and apart from some of the other, like from the FLA settlements in some cases. And I work with OHIP because I want them to dive deep. I want them to take a hard look and make sure that they're putting in absolutely everything. And I had one defense counsel argue to me, well, their stay really only should have been 6 weeks in the hospital, but because they were waiting for a bed to open up, they were there for 3 months, so we shouldn't have to pay those, the rest of those weeks. And I said, well, hold on a second. Under the Long-Term Care Homes Act, you're allowed to give away their bed after 30 days of being absent from the home. So after 30 days, if someone's in the hospital, they can lose their bed, which means they have no other recourse but to wait for another bed to open up. I say, no, there's no reduction. And in that case, OHIP's claim was $140,000. So there is good money to be had in these cases if you pile these damages together. You take someone with a fractured hip that needed surgery, is in the hospital, has 2 adult children with 3 adult grandchildren, you're looking at a $250,000 case.
Yeah, absolutely. And again, add in that time to placement that we mentioned at the very start. Like, average time to placement is 161 days. So if you lose your place in line or your bed, so to speak, those costs can go up exponentially.
Yeah. So the one other thing I should have mentioned under pre-litigation considerations is there is a hard and fast limitation period under the Trustee Act of 2 years from the date of death. So while you can argue consent and capacity can TOLA limitation period, and you can argue discoverability. If that person died, none of those discoverability or consent and capacity issues matter to TOLA limitation period. You're stuck. So you got to make sure that you're keeping an eye out for that and diarizing accordingly. So that's it for our presentation. Love this picture. Cute man. If any of you have any questions, I know, Mike, I think you've got some questions people might have been typing in where we've got a few minutes and we can answer them.
Yeah, thanks, Melissa. I do have some questions for you both. We'll start with the first. What are your thoughts on using Rule 10.02 if a person dies, no will, and estate not worth probate?
Hold on a second. I'm gonna, you know what? Let me look up 10.02, and then while Eric is answering another question, Mike.
I guess that's
okay.
Is that the offer to settle? Anyways,
let me look it up.
I think
quickly.
it's under the thing.
Shall I go on with another question? Shall I proceed with another question in the time?
Yeah. Ask another question while I'm looking at this.
All right. What type of experts do you use to demonstrate negligence against the nursing home?
So experts that I've often used from the outset, you need nursing experts most of the time. Wound care expert, somebody who has actually worked in long-term care facilities. You really do want someone who's been in the trenches, so to speak, but can also speak to it on a higher level. So you have nursing experts, you've got geriatricians, and obviously you need to speak, to have an expert be able to speak to causation. So oftentimes you'll have a cause of death that might be a little bit murky, and you'll have an incident or some sort of negligence. And again, as I mentioned before, really, really important to be able to connect the two, especially when you're considering Family Law Act claims. So again, nursing experts, geriatricians, very, very important and most often used.
Yeah, and I mean, like in the odd case, like I have a case right now where I'm dealing with a late, I don't want to call it late diagnosis of a heart attack, but the nursing staff didn't see the signs properly, and this man was having a heart attack right in front of them for 2.5 hours, which was, you know, longer than they should have waited to call an ambulance and get him to a hospital. But the issue is, would he have died from the heart attack anyways? And so I needed to consult with a cardiac expert on that case. I'm just in the preliminary investigation stages, and it's not looking good, but, you know, that's someone that I needed to consult with outside. Okay, so going back to the 10.02 question, so that rule is with respect to the representation of a deceased person. It gives the court authority to appoint someone where there's no executor or estate administrator. So you've got a litigation administrator, basically. And yes, you can use that section or the appointment of a litigation administrator on behalf of the estate in litigation to gain access to records, but that doesn't help you when you're investigating the case. And you shouldn't be waiting to get records until you've started a lawsuit. That, in my book, is how you run into problems, because you're hearing a very sad and emotional and sympathetic story from the family, but you got to be able to back that up. So I look at records before a retainer is even signed in 99% of my nursing home cases. And unless I've got like a scathing ministry report or something like that, which is why I come back to the fact that if there isn't an executor or an estate administrator appointed in order to be able to sign authorizations to get records, then you can try to use a next of kinship and use that birth certificate or marriage certificate or something like that.
Right, and I might be wrong on this, but you don't necessarily need to have like an executor to be able to get somebody's records from a long-term care facility. So that's not sort of a prerequisite for you to be able to access somebody's file.
Yeah.
Usually you'll have a loved one who was helping to provide care for somebody in a facility. That person is often the best person to go to in terms of having them go to the home and request those records themselves.
Yeah, I always get my clients to request the records themselves before the home knows that a lawyer is involved. I think optically, look, I don't trust what they do to some of these records, and my nursing experts have found some tampering with records, so I don't trust them. And I want to see what they give my clients before there's ever production by way of litigation, and compare them if necessary. And yeah, you know, sometimes if the family member goes in, they'll just kind of give them to them. Same thing with the hospital. Sometimes they overlook the requirement to have that executor or representative appointed because they know they were POA. It's a mistake. They shouldn't. But by and large, I get my clients to use the FIPA form, which there's a link to it on my website if you want it, because there's a remedy under FIPA that if the records are not provided within 30 days, they have a remedy to the privacy commissioner. And I've had a client use that, and I'm going to use that as leverage in the lawsuit as to why the home wasn't prepared to give the records in the first place. It looks bad, and it affects their credibility, in my opinion. So, you know, that's why I always get my clients to do that. They get it faster, it's quick access, and it doesn't alert them that a lawyer's involved right away.
And that actually sort of raises another point in a similar vein, is understand what it is that you need to get produced, right? Like, homes are only going to give you what you're asking for most of the time. And if you're not asking for the right stuff, policies or contracts of employment with a doctor, like, if you don't know what to ask for, they're not going to help you along. That's for sure.
Yeah, like I always itemize that I want the care plan, I want the contract, I want all labs and test results, I want progress notes, flow sheets, physician orders. The medication administration record is a big one. That's where you'll often find errors, which you might not even be looking at it from a medication error case, but the person fell because they didn't receive their medication on time. My nursing expert has found that a number of times and has been able to link a single instant negligence to a bigger systemic issue. So that's a really important record to request. You know, so those are, like, I send an email to my clients after I've spoken with them, and I say, here's the list of stuff that you need, put it on a FIPA form, go get the records, and if anything is missing from that, I make note of it and I raise hell. Mike, are there any other questions from anybody?
Yeah, I do have a few more if we have a few more minutes. Am I required
I think we have time for one more.
Okay. Am I required to put OHIP on notice for LTCH or nursing home claims?
We covered that one, actually, I think.
Yeah, so not necessarily. Look, if it's solely an FLA, OHIP has no subrogated interest. So, you know, I guess the short answer, again, only where OHIP has a stake.
Yeah. So I guess we have time for one more then.
Yeah. How can I enlist the help of the Ministry of Long-Term Care with respect to investigating a potential claim?
So that's a great one, Mike, and we touched on it in our presentation. The action line, 1-866-434-0144. You should have that like taped to your desk basically when you're speaking to clients and potential clients. You can always just Google search, find long-term care homes in Ontario. Very basic search should bring you to the health.gov website, and you can find, you know, every single incident report or critical incident report that has ever been documented about a care facility. So just really helpful insights that are found there.
And like, if anybody else has any questions, feel free to contact Eric or myself. You know, I mean, I don't feel any proprietary right to any of this information. I want more people to be litigating in these cases. I want to put pressure on the insurers on behalf of the home, who, by the way, the insurer on behalf of most of these homes is unfortunately Aviva, by and large. But you do get very experienced adjusters, in my experience, you know, not ones that are taking, you know, defensible positions for the most part. So you'll have a very senior person or a very knowledgeable person on the other side, which makes it a little bit less painful. But yeah, I mean, at the end of the day, the more people who are taking these cases on and representing this segment of our population, in my opinion, the better.
Yeah, there's certainly more than enough to go around. Like, if you just look at our population demographics, this is this is an issue that's going to keep rearing its head, and I think we have an obligation as a legal community to to satisfy this need from our population.
Yeah, so that's it for us, and thanks, Mike.
Thank you, Mike.
That's wonderful. Thank you so much, Melissa and Eric. That was very informative. Thank you, attendees, for joining us today. There is a brief survey that will pop up once this program ends. Please take a couple of seconds to give us your feedback. We would greatly appreciate it. Our next webinar is on Tuesday, January 21st, and is titled Mediation and Arbitration, Thinking Outside the Box, hosted by Justice Richard Gates and Greg Monforton. Registration is open for our medical malpractice conference being held in Toronto on February 28th. You can also find a full listing of speakers on the brochure at OTLA.com. And mark your calendars for our 2020 Spring Conference in Toronto on May 8th. Registration will be open soon. You can find more details and the full events list on OTLA.com by clicking on Calendar under the CLE and Events tab of our main menu. On behalf of our speakers and the Ontario Trial Lawyers Association, thank you for attending our presentation and have a wonderful day.